All right, hi everyone. Hi everyone. Welcome back. Welcome back. Hope you have a nice day. I see a couple of you. Well, you missed the debate, but how did it go? Did it go well? Very good. So some of your colleagues organized a very interesting discussion on immigration. I stayed for a brief bit of it, but I had to go and prepare for this class, among other things. So I hope you all enjoyed it. I had a crazy day yesterday. So I was invited to give a lecture at Baylor, and I had an event at UT Austin in the same day. So I left really early, and I managed to drive through College Station. So I went to A&M. I actually saw the George Bush Library for about 20 minutes. I actually went in and out in 20 minutes because all the time I had. I got a picture at the Oval Office desk, which is kind of nice. And then I drove to Baylor, and I gave a lecture at the law school there. And then I drove straight to Austin. I gave a talk there, and I got back around midnight last night. So it was a very interesting day. But I got to see actually the three main football stadiums in Texas for college football, which was kind of nice. I had never seen I've been to Austin before. I hadn't been to College Station or Baylor before. And the new Baylor stadium is very pretty. I really liked it. Has anyone seen it yet? Been to a game? No Baylor people here? You saw it? Yeah? Is it nice? Yeah, it's really cool. The Brazos River comes right up to the banks of the stadium. So you can go sailgating. Right, you can actually bring that's what they call it. Instead of tailgating, sailgating, because you bring your boat right. Oh, come on. That's funny. That's good. It's a pun. So you can bring your boat right up. Just, but, boating under the influence is probably a problem. BUI, right? Anyway, well, that was my day yesterday. Anyone have anything else fun, interesting, anything on your minds? Nothing. Shh. Quiet, everyone. Good. Very good. Okay. Any questions on easements from what we did yesterday, or Monday, that is? Days blur together. I don't have days anymore. Could have skipped College Station. Actually, I couldn't because the GPS told me to go there. I actually wasn't planning on going to College Station, but the GPS took me through. I said, oh, well, there's a sign for the George Bush Presidential Library, and I'd been to that one. I'd been to the LBJ one. I've been to the Jerry Ford one. I've been to the Clinton one in Little Rock, so I wanted to add one to my list. Eventually, I'll go to the one in Dallas for W. Bush, but I haven't been to the H.W. Bush. So this one was really nice. I liked it. What was kind of cool is they actually let you go up to this fake Oval Office, and you can actually sit in the big chair, and it's a really nice chair. The president has sat in it, so it's a legit chair. And like you can pick up the phone and act all self-important and go to the Situation Room and decide to bomb Iraq. It's become a tradition at this point. So it's. I had a weird deja vu as I walked through each of the recent presidential libraries. Each have like an exhibit like bombing Iraq. Anyway. So I digress. All right, so let's talk about easements, something much more interesting. Okay. In our last class, I introduced this concept of easements. And effectively, an easement is allowing someone to do something on your property or not do something on your property. Okay. The general gist of an easement is two parties come together and they make an agreement about how land should be used. And we introduced this concept of easements, easements in gross and easements appurtenant, right? We said an easement in gross means a specific person receives a benefit of an easement. So if I own a piece of land and there's some land next to me that's water, if I have an easement in gross, I can cross that land to get water regardless of where I live. But that's the exception. The general norm is something called an easement appurtenant, right? An easement appurtenant means the benefit of an easement belongs to the owner of a given piece of land. So if Blackacre has an easement appurtenant to Whiteacre and I sell Blackacre, whoever the new owner is of Blackacre gets a benefit from that easement. Okay. We also introduced these concepts of dominant and servient estates, and this one is self-explanatory. The dominant estate is the estate which reaps the benefit, right? It benefits from the easement. And the servient estate is the estate that suffers, that serves, that bears the burden of the easement. Okay. Any questions on that so far? Is that a hand or you just think? Okay. We also discussed this notions of easement by estoppel and licenses. So generally speaking, and we'll do this more today, you need to have an easement in writing. It has to be writing to satisfy the statute or frauds. But there might be cases where out of concern for fairness or reliance, the court might actually impose an easement as a matter of estoppel. The case we did involve a road, and someone's put a lot of money to improving this public road, and they actually found that there was an easement as a matter of estoppel. Okay. We also talked about licenses. Licenses are not usually written down. They're just oral permissions to enter land. They can be written, but they're usually not. And the thing about oral licenses is they can be revoked at any time. You can usually stop it. The exception to that is, again, estoppel, right? If you have some sort of reliance interest, you can't revoke it. The courts might actually make you have the easement, make the license become permanent. And those are fairly rare. Okay, so that's review. Any questions about that from last class? Okay, so today we'll continue talking about easements and focus on a couple different types of what are called implied easements. All right, where did I finish last time? Who was up? Oh, thank you, Alex. Okay, so Alex, I think I called in you. No, I called in you. Yeah, I was the last person. Okay, so Haley, sorry, there you go. What does the word implied mean? Generally speaking, in law, you see this word in a lot of your courses.
It's not written. It's just.
Don't say implied. No. Who's? Well, let me this way. Who's doing the implication? Yes, the court. Okay. Implied is not an arrangement reached by two people. Implied means the courts read it into it, right? So you can have an agreement implied by law. You always see it's implied by law. Okay, what does it actually mean? The courts are doing it. The court's saying, well, yeah, you two didn't come to this arrangement, but because of whatever reason, we will pretend as if you did, right? We will imply, in this case, an easement. Okay? So even if two parties don't come to an agreement of how to structure an easement, the courts can step in and imply one. And there are generally two circumstances under which a court may imply an easement. And Aisha, the court mentions this quasi-easement. What's a quasi-easement? I'm sorry? Not partial exactly. Katie, what does it mean to have a quasi-easement? Implied from what? This is a term that's defined in the book. I'm not sure why you're struggling. Adam, you got this? I mean, it's right at the beginning. Zoe? Louder, please.
It's an easement implied from prior existing use.
Yes. Okay. So what a quasi-easement means is that it's implied from some sort of prior use. So there's a case in the book which I didn't assign because it's too long and complicated, but the situation is like this. You have a series of houses that are connected, and underneath them, there's a sewage line, right? The only way to get rid of your sewage from your house is to have it go in this tube underneath it. Now, the parties never actually reached an agreement to have an easement to dump their waste, but that's how it's been done for many years. So it comes to be that some new guy moves in and says, you know what? I don't want these people dumping literally their crap underneath my house because there's some flooding. So he basically turned off their sewage pipes, okay? And there was no other manner to which they could actually access the main sewage line because the guy turned it off. So the court actually implied an easement, what he called a quasi-easement, saying based on prior use, you've been using this for a while. This is not prescription or adverse possession, but they're implying it as a matter of fairness based on prior use, that the two parties had come to rely on this and you can't suddenly disrupt it. So we're going to see that. Well, let's try again, Aisha. What's an easement by necessity? Do you have it? Do you have it? Well, be more precise. Why would there be an easement by necessity?
The party is having using it, or a party has been using it. So there's like a land, and then, for example, a person crossing the road, and
Mm-hmm. You're saying the right things, but not exactly. Adam, what does it mean to have an easement by necessity? You're on the right track.
The necessity, it means that there's no other possible way that they can use it. And I don't want to get into the first case yet, but they talk about there's no physical other way for them to use the road. So it's something that is absolutely necessary for that person, and it becomes an easement by necessity.
Okay, good. So the second kind of implied easement, I'm scrolling really fast, so I want to find the picture that I'm looking for. I forget what page it's on. The second type of easement is called easement implied by necessity, okay? What does that mean? Almost invariably, it refers to landlocked. Yeah, here it is. This is the picture I'm looking for. Almost invariably, it refers to pieces of property that are landlocked, okay? It's presumed that you should have access to a public road. So if you're poor number 5, right? You're poor number 5. You're stuck in the middle. We'll come back to this question later. But if you're poor number 5, right? The only way for you to get to the public road is to commit a trespass. The only way you can get to the road is by trespassing over 1, 2, 3, or 4. You have no other options. Okay? Don't say helicopter.
Why would somebody buy a property?
We're going to do that later. No, and that's a very good question, but we're going to answer that later. Okay? The law actually takes care of that. But if you're number 5, right, you have no way of getting out. So what the courts will actually do is they can imply an easement as a matter of law based on necessity. They're saying, listen, you have no other way of getting out. So we're going to say, you know what? The shortest distance from your property line to the road is 3. I mean, here they look all equal. Let's assume that 3 is the shortest distance. We're going to give you an easement across 3's property, right? You're going to now be the a dominant tenement, and then 3 will be the servient tenement. This will be an easement appurtenant. And what the court actually does is it writes an easement as a matter of law. So now if you check on the deed of number 3, you'll see that he used to have fee simple. Now he has fee simple with this easement on it, right? They just diminish significantly the property value of 3, okay? And before we get too far, I want you to appreciate, it sounds great, right, to imply easements, right? It sounds wonderful if people really need it. But more likely than not, 3 was not at fault in this case. Perhaps he did absolutely nothing wrong. Yet the property value of 3 has been diminished significantly because now you have to allow the owner of 5 to cross at any time. Right? So there are certain costs to this. Now, we'll discuss this in the case, but different jurisdictions understand necessity differently. The Othen v. Rosier case, this is the case from Texas, defines it very strictly. In fact, it has to be absolutely necessary, right? The only way of getting to the road is by committing a trespass. Only when that happens will they imply an easement.
What would happen after the judgment came?
We're going to do this question like in 15 minutes. We'll come back to it. Okay? We'll come back to one, I promise. So generally speaking, right, courts like in Texas and New York and elsewhere say strictly necessary. So I think just one example mentioned in your book where the court found that someone was landlocked or surrounded by water. And they actually said, well, they could build a bridge, right? And the cost of building the bridge was like $700,000. I said, well, build a bridge, right? Yeah, Zoe.
That wasn't a bridge. That was when the only way out was down a really tall
Yeah,
steep
okay.
cliff.
Yes, you're right. So, I mean, basically, you could be effectively landlocked. You have no access to a direct road, right? But they can imply, they can say this is not absolutely necessary. In other jurisdictions, I think they mentioned Illinois, you can have a situation where it's, you know, not absolutely necessary, but pretty necessary, right? It would maybe impose too much of a burden otherwise, okay? But the issue in the first case with the one from Texas is you're taking a strictly necessary view about how they define necessity. Okay. All right. Any questions before we start the first case? Yeah.
My question is, 5 is obviously landlocked, so he's going to get an easement through, I guess, the quickest way possible. So we said 3 to that public road, I guess we'll call it, on the south side. But let's say that that these are huge parcels of land, and that even if you were to get to the public road on the south side, you'd have to go like 50 miles around to get to the north road. Could you get another easement to go through 1 and 2's land because of the burden of having to go around some?
Right. So, I mean, the tricky issue is, and we'll do this specific question later, but if the court's confronted with, say, 4 different plots to burden, they'll probably pick the one where there's the least burden to the property holder. Right. So if they can get you just crossing 3 without crossing 1 and 2, they probably will. Like, they're going to try and do the least amount of damage. Other questions? All right. Let's do the facts of the Othen case, which is one of the few Texas cases we have. All right. So just at a high level, Adam, what happened here in Othen? We'll that Adam. Yeah, you. I already did you, so you. Yeah, you're next.
Basically, there was a piece of land owned by Hill. He sold it to two different buyers, and Othen's land was landlocked behind Rosier's land and had no way to access the road other than trespassing through the Rosier land. And basically, he was using it for a while, and there was a levee, and there was, you know, took off the levee, the water flooded onto the road and made it very muddy.
The levee wasn't dry.
Right. And so.
Oh, come on. You don't get that one? Oh, God. Keep going. Sorry.
So there was no way to pass through the road, and so he applied for exemption.
Okay, good. American Pie, right? Thank you. Wow. Cultural literacy is very important. You'd be surprised how much is okay. So the website for the book has this actually very helpful animation which walks you through it. Okay. So for the time being, we have this plot of land called the Cone Survey. Okay. The main road was this Beltline Road. These other roads pretend they don't exist, right? Because one of them, it wasn't clear when it was built. The other one, it probably built some later. So pretend the only public road is this one coming right up here, okay? And there were a number of conveyances, and some of these conveyances were transferred through intermediaries. I don't really care. We only care about what's owned by Othen and what's owned by Rosier. I don't really care about the intermediary people because it just confuses you. The word mesne, which you might have read, you might remember that from Property 1, means intermediate. So a mesne conveyance means between here and here, someone else had in the middle. I don't care about those people, okay? So the first transaction, right, was in 1896. You might want to keep a timeline because the timing is important. The first transaction is 1896, and Rosier sold 100 acres. And so Rosier purchased 100 acres, okay? So what I want to do to make this case make more sense is understand Hill, okay? Hill owned effectively this entire plot of land. And we start from the presumption that Hill is not an idiot. This is effectively, I think, what Adam was asking at before, right? Kevin, would anyone ever knowingly make a transaction that landlocks them?
Probably not.
Okay, that's a fair statement. Generally speaking, a person will never go ahead and make a transaction that landlocks him, because that would be stupid. You're basically setting yourself for a trespass every time you want to go somewhere. So the law in Texas and elsewhere evolved to this point where if someone's making a land transaction that would landlock them, even if they didn't reserve an easement, we'll pretend as if they did, right? If someone made a transaction for land that landlocked them, we will make believe, we will imply as a matter of law that they had reserved an easement for themselves. Okay? Everyone get that? The reason why is because, again, we don't think people landlock themselves, and perhaps they just forgot or made a stupid mistake. The law will cover for them. The law will cover their mistakes. So at each juncture, when Hill starts making transactions, the question we have to ask ourselves, is he landlocked, right? If the answer is no, then we're fine. If the answer is yes, he's landlocked, then we have to assume that he reserved an easement for himself. Everyone see that? Okay. All right, so the first transaction was made 100 acres right adjacent to the road, okay? So at this point, Monica, is Hill landlocking himself? No, okay, that's right. Look, he has every way around it. You can go here, you can go here. Okay, so he has other avenues of egress. Egress is exit if you want to be cool, okay? The second transaction, okay, now in 1897, so 1 year later, okay? This was bought by someone else, but was eventually sold to Othen. This was a 60-acre block, okay? So, Aleda, let's look at this two different ways. If you're Hill at this point, right, are you landlocked?
Yeah.
How come you're not landlocked? Right. You can go north, you can go south, right? So when Hill sold this land, Was there any need to reserve an easement here? Okay. So, Victoria, let me ask you a slightly different question, though. Right? When Othen bought this land, should he have been maybe a little bit nervous? When Othen's predecessors bought that plot, should he have been nervous? Why? Well, how does he get to the road if this is the only piece of land you buy? Hill sold this to Othen. It wasn't actually Othen, but pretend it was him, right? When Othen bought this, how was he planning on getting to the main road? Yeah, how is he going to get to this road? Whose land is that? Ah, right. So again, Hill owns all the green, right? Hill owns all the green. Othen bought this pink block right here. When Othen bought that block, should he have been suspicious? Why? Okay. So when Othen's predecessor bought this, he should have been on the thinking, wait a minute. I'm buying this, and I can't get out. Now, as a matter of course, this is all Texas prairie land. I'm sure they just drove across it, and there wasn't an issue, right? They probably didn't even think about it. But if we're sophisticated property students here, right? You're screwed here, right? You're landlocked. You're like number 5. But what's interesting is that when we talk about reserving the easements, we're not talking about for the poor guy over here. We're talking about Hill, right? When we're talking about whether an easement's reserved or not, it's not whether the buyer is going to get screwed. It's whether the seller's going to landlock himself. So the only question we're asking ourselves at this juncture is, and then Victoria, is Hill, the owner of the green, landlocked? Okay, that's right. Everyone see that. At this juncture, Hill is not yet landlocked, or he won't be ever, really. Okay? All right, so let's go to the next transaction. Okay, so 1899, so a couple years later, Hill sold another 53 acres above. Right? So Mike, at this juncture, is Hill landlocked? How come?
He still has the same access as he had before.
Yeah, you can go top, you can go bottom, doesn't really matter. You can go wherever you want. What about Othen? Is Othen still in trouble? Okay, Othen's still in trouble, right? But that's not the relevant inquiry. The relevant inquiry is the seller, Hill. Okay? Now, okay, there's one more transaction. All right? So Rosier now has this little square here, right? What do you think, Zach? At this point, is Hill landlocked? I'm repeating the same question over and over again. Okay. What about Othen?
Still.
Okay, he's still in trouble, right? And now he basically has to walk along this little, this little switch right here, trespass the road. That's the only way he can do it. But what he actually does, and the picture draws a diagram, is that for a number of years there was a roadway that cut across Othen's property. Okay. All right. So everyone see that? That's what happened. So before we get to the easement, let's talk about prescription. So Parsa, we did this last class. What does prescription mean? Prescription. Nothing to do with medicine. What's prescription? Jordan?
It's basically the same as adverse possession, but it's just for the use.
Yes, right, exactly right. Prescription is like adverse possession just for the use. And again, I think I mentioned this, but if you go down to Louisiana Street, a few blocks from here, you'll see on the corner of each street, it says, this is a private road, and you are using this at our discretion or with our permission, right? So Parsa, why would the Shell building put that in front of their sidewalk? What are they trying to do there? Why would the Shell company tell you you are using the sidewalk with our permission? What do you think they're trying to do there? What are the elements of adverse possession? Hostile, right? Can something be hostile if you have permission? Okay, that's the deal right there, right? The reason why they say you're walking across this without permission is to rebut any possible claims of hostility, right? It can't be hostile if you have permission. You often see this on beaches, and we'll get to beaches in a few minutes, where you'll see you can, if there's a house and then there's a beach, you can cross through the public sand, right? You say you are crossing this without permission. What you probably never realize is that piece of sand probably belongs to someone, but they want to make sure you don't make an adverse possession claim to it. Okay, so go back to prescription. Okay, so Andrew, what's the problem with prescription in this case? In this case, he crossed that path for quite some time, right? Why didn't he get it through prescription? Yeah, okay. And that's the issue. For many years, he was crossing that path with permission. If you're crossing the path with permission, you don't get adverse possession, you don't get prescription. Okay, everyone see that? Okay, so let's go on to the actual easement issue, okay? The way the easement issue works is an easement is reserved if Hill, the seller, would landlock himself, right? Zach, at any point, did Hill landlock himself? He never did. So is there ever any easement reserved? Okay. And again, why didn't he landlock himself? North and south. Okay. At any given point, Hill always was able to go north and south. Therefore, there was no need to reserve any easements. Right? So he loses. There's no implied easement, right? Kelsey, would there be an easement by necessity here?
No,
How come?
because it must have been a necessity for the previous owner in order to carry over to.
Well, I'm not talking now about the implied easement, right? From the previous from the previous reservations. Why can't he claim that, look, I'm like guy number 5. I'm stuck here in the middle. Easement by necessity. He's like the guy who's landlocked in the middle of a lake. Why can't he claim necessity here?
Because he was aware of it when he bought the land, like where it was located.
No, Michelle. Why can't he actually make a claim for necessity, totally apart from these reservations?
Well, it wasn't in like the original deed or anything.
No.
The court called it a mere convenience. It was just a convenience to him. It wasn't a necessity.
Okay, that's right. So here the Texas court takes a very strict view. They say it has to be strictly necessary, right? Strictly necessary. Okay, but that's a tricky one. Claire, let me ask you, what were his other options? I don't know if anyone had this thought when they read the case, but what exactly is his plan B here?
Drive off another area.
He's trespassing. The second he touches the greens, like touching the lava, right? He's trespassing. What the heck? Yeah, David. What's the other option? How is this not absolutely necessary?
Could have contacted Rosier to ensure that he could, or he could have.
Rosier said, "No, I don't want you here." He already put, the levee was not dry.
So he could have gotten the easement from Hill.
Yes. Okay, and this is why the Texas court ruled against him, right? You had land to the north, you had land to the south. Did he ever approach them and say, "Hey, can I buy an easement?" Well, actually, if you read the aftermath of the case, he did just that. That the party to the south, who owned the southern land, let him cross. So, in that sense, the Texas courts got it right. It wasn't absolutely necessary. It was convenient. He could have bought the easement from someone else. So rather than the court diminishing the value of Rosier's land by putting an easement across his deed, let the guy buy it from somewhere else. He has land to the north, he has land to the south, he has this road, he has that road, right? This is why the strictly necessary doctrine, I think, works fairly well, for the most part, right? If there's a way that you can get to the road without burdening someone else's property, meaning you pay for it yourself, then do that first. Maybe you can imagine a circumstance where he asks the guy to the north, he says no. He asks the guy to the south, he says no. He asks the guy to the east, he says no. If all of them say no, okay, then he can go to court and say, listen, I'm stuck. I'm absolutely stuck. Help me out here. And I suspect the court might have a different answer in that case.
Let's say they all say no, and he's already asked to pay. Do we have to pay then, or do we just do?
Well, that we'll do this question in a minute, which I ducked before. So I'll postpone your question briefly. But that's this case, right? That's this case. All right. So any questions about the Rosier case, right? This is effectively a situation where the court said it's not absolutely necessary to give you an implied easement. Go buy it yourself. And if you can't buy it yourself, come back, tell us, and then maybe we'll give you a judgment. And if you read the aftermath of the case, they make pretty clear that, you know, they were allowed to cross on the land right below it. So the court was actually right in that sense. They were able to find another path. Okay. Everyone see that? All right. Let's do this question number 2. I think it's a nice it's a nice summary. So Blaine, could you please read question number 2? Okay, I'm going to keep stopping it, but I'll let you come back in a second. So this is actually effectively the question we just did with a much more nicer picture, right? So A owns all of the plots 1, 2, 3, 4, 5, right? So Blaine, at the time, is A landlocked? Why? Yeah, A owns everything. So even though technically this piece is in the middle, A owns the rounds around it. So when you have fee simple, you can't trespass against yourself. All right, keep reading, please. Okay.
Lots 1 and 2 are bounded by a public road on the north.
Keep reading, yeah. I'll keep the picture up here.
4 are bounded by a public road on the south. Lot 5 has no access to the public road except through one of the other 4 lots.
Okay.
A dies intestate.
Everyone knows what intestate means. That means with no will, right? Okay.
For 5 children, B, C, D, E, and F are heirs. In the decree of distribution, settling A's estate before signs lot 1 to B, lot 2 to C, lot 3 to D, lot 4 to E, and lot 5 to F. Nothing is said in the decree about lot 5 having an easement away. Sometime later, F sues the.
Okay, stop right there. All right, so I want you to walk through this with me one step at a time, right? So before A, O owns all of it, right? O owns all the property, right? What you have to keep in mind is that O will not landlock himself. O will never do that. Ready? Okay, so Stephen, let's walk through this, okay? O owns number 1, right? He sells it to A. Is there any landlocking problem at this point? O owns number 2, and now he sold 1 and 2. Is there any landlocking problem? So O is now sold 1, 2, and 3 to A. Is there any landlocking problem? Okay, Stephen. Now O is about to sell lot 4 to A. Is there any landlocking problem? Probably, or is it done as a matter of law? See, here's the thing. When O owns all of these, the second he sells 4, 5 becomes landlocked, right? We assume, as a matter of law, that when O sold 4, he reserved an easement. Everyone see that? When O sold 4, he reserved an easement. So whether or not he actually did it, right, there's an easement reserved on 4. Okay? Everyone see that? So now on the deed of 4, there's effectively an implied easement based on necessity. Okay? But, Alex, what happens once A buys number 5?
The easement that was understood to be before.
That's right. An easement by necessity only lasts as long as it's necessary, right? Once A has bought 5, he has fee simple the entire lot. He doesn't need the easement anymore. The easement dissolves. Right? So immediately when 4 was sold, there was an easement by necessity there. But once A is now bought 5 and thus owns everything fee simple, the easement by necessity dissolves.
Does the law say like which side you get the easement, or is it whatever's convenient?
Well,
Whichever keeps the property?
well, but in this case, it's based on the sequencing, right?
No, I mean, which side of 4? Like, you get it up to the 4.
Oh, that's the question Hugo asked me before. It's usually the shortest possible distance, the shortest reasonable distance across the land. So in this case, it's a square, so it doesn't really matter. Yeah.
You just mentioned that whenever O sells 4, then unlocking 5, that I guess it's implied that he reserved his easement for 5. Now, since we're talking about the shortest distance, does that mean that that easement will transfer to either one of those lots as long as it is indeed the shortest distance, or does it have to strictly stay?
Yes. Yes. I mean,
Rotating.
the thing about an implied easement is it's not written down until much later, right? A court has to actually find this implied easement, so the court will define what it is. All right. So again, there was an easement across 4, but the second 5 was purchased, the entire lot was owned fee simple. That easement by necessity dissolves. Everyone see that? Okay. So now when A died intestate, he has 5 children, right? Lot 1 is for B, lot 2 is for C, lot 3 is for D, lot 4 is for E, and lot 5 is F'd, right? Oh, come on, did you miss that? Oh, God. See, this is why you have to pay attention. I'm not repeating it. You can watch the video. Right. So poor lot F, right? He's in trouble. He's landlocked, okay? Does, let's see, Zugi, what's that? Zuhei. So, Zuhei, does the previous easement across 4 help at all, F? Because it's been dissolved, right? So what happens now? What happens in the next case? How does F get out?
By necessity, there's really no other way.
Yes. So effectively, F would have to again show by necessity, and he could cross. We don't necessarily which one is probably 4, 3, 1, or 2, whichever one is closest, whichever one has the least burden, right? And again, we're assuming that all of F's brothers and sisters are ingrates, and they won't let their poor brother cross out, right?
So do you have to offer to buy easement before you have necessity?
If you're in the Texas standard, you should probably show that you tried and failed. Because, I mean, you have to show it's absolutely necessary. If you can buy an easement from 1, 2, or 3, or 4, then you should do that. I mean, if they unreasonably say no, then that's a better case for necessity.
And would the state apply like a reasonable cost? I mean, as you mentioned about the bridge,
If you're on the strictly necessary standard, you can build a $700,000 bridge to go down a cliff, and that's an option, right? I mean, I think anything short of like a helicopter, you know, I guess you have air rights too in that case. But generally speaking, yeah, you're stuck.
And he doesn't have to pay for it to go to court.
Okay, so what's interesting though is generally speaking, we're going to do a case about this in the next class. So in some cases, the court actually orders payment for the easement. In some cases, they don't. And I don't have a consistent rule why or why not. But we're going to do a case, I think, next week where this is actually an issue where the court ordered a payment for the easement.
And since these tracts of land lose property value as soon as the easement is
Yes.
on them, would a fair assessment of the cost be the loss in property?
Exactly. So the cost of the easement isn't just whatever damage you caused by walking across it. You're now compensating for the perpetual loss in value of having this easement. Because once you have an easement on a piece of land, it's there forever and ever and ever and ever and ever. You can't get rid of it, right? It goes on forever. So you are now diminishing for eternity, effectively, the value of the land.
It's a necessity.
Will this necessity ever end? Unless poor F buys one of the other lots, there will always be a need.
Well, what if 2 eases up and just allows him to?
Okay, then it'll dissolve, right? So if the future owner allows the crossing, that's fine. At that point, the necessity easement will dissolve.
Would the court consider not having 5 or F pay the cost if he went to both 1, 2, 3, 4, and all of them denied him that right. So then whenever they forced an easement so he could have access.
Yeah, I mean, that might be one of the factors. If you unreasonably withhold access, right, then that might work against your favor. But, you know, you have to at least try, right? You can't build a tunnel or a helicopter or something. Tunneling would also be bad. That'd be a trespass as well because it's subsurface rights, so you can't even tunnel. All right, other questions on this? Okay. So, I mean, the notes afterwards, it explains, again, how the easement by necessity only lasts so long as the necessity is there. Oh, there's an interesting a case mentioned in the notes where there was a Bel Air, California country club, and they keep hitting golf balls. And they keep hitting golf balls for year after year after year. And then they claim that there's actually a trespass. And the golf club actually said that they gained a prescriptive right to hit balls there because they had done this for so many years without any effort to stop them. It definitely wasn't permissive. It was hostile. I'm not quite sure how the case came out, but it's a weird situation where you have these odd claims for a prescriptive easements. All right. Anything else before we turn to the beach? Go to my second home, the Jersey Shore. Not mostly kidding. Okay. All right. So let's talk about the beach. So you may have never thought much about this. I guess we have only beach around here. I guess is in Galveston, and which is not very nice. I went there a couple times. I was really disappointed. The water is really dark. That's what I noticed. Like I've been to the other side of the Gulf on the Florida side, and it's beautiful. I don't know what happens between Florida and like Texas, maybe Louisiana, but something happens to it, and yeah, it's not very nice. Was it? I've not been to. Is Mississippi Gulf nicer? Oh, so you're blaming Mississippi? That's what messes up the beach. Okay, fine. I can't even spell, too many S's, right? So yeah, the beach isn't very nice, but in most places, beaches tend to be very pretty. And we have this system of law, which is often called the public trust doctrine. So generally speaking, no one owns the high seas, right? No one owns the waters. The waters belong to the public, and then more precisely, within a certain number of miles, the water belongs to the sovereign, the country, as it were. So it's good enough to say that no one owns the water, right? We all have access. We can all go swimming. We can all go boating, okay? But how do you get to the water, right? Well, obviously, you have to cross from dry land to sand. There's actually a sand in Galveston. There is some, right? So you cross from dry land to sand, and then from the sand, you go to the kind of, the wet sand right near the tide line, and then you get into the water, right? So historically, the water was public, right? I'm going to call it wet sand, which was, you can see right here, which is right near the shore, right, where the tide washes up. That was also public because you have to be able to walk into the water, okay? What about the ability to walk to the sand, right? To walk from the dry land to the sand. And historically also, that was also public. That makes sense. There's no way to get to the water other than to walk across the dry land to the sand there. So generally speaking, historically, what was public, right? The water was public, a couple feet, say 3 feet, where the tide comes in, and kind of like a vertical path to get from the dry dock to the water. Okay, that was public. That belonged to the state. Okay. So let's see, Daniela, what happens if you owned this plot of land under the common law before New Jersey ruined it, right? What happened to the common law? If you own that plot of land, what could you do? What could you not do in your land? Well, be very precise. Could you block them from accessing the water? Okay, you can't block them from accessing the water. Can you block them from accessing this 3 feet strip right by where the tide comes in? Under the common law. Louder? Say it, you're right.
No.
The answer is no. But under the common law, could you restrict them from accessing you know, the dry sand, this area over here, where all the beaches and umbrellas are. That's right. Under the common law, the public had access to the water. They had access to this like 3 feet strip near the water, and they had access to the vertical access to the beach. Okay. But if you owned that land, you could keep stuff on the dry sand. Everyone knows what I mean by dry sand. There's always a little bit of wet sand. The rest of it's dry sand, right? You could keep the dry sand. So has anyone ever been a member of a beach club or anything like that? Do they even have those in Gallup? No one would pay. Yeah, I know. It's probably no one would pay for a private beach. So I mean, it wouldn't work. So in theory, though, if you have a nice beach, you can actually pay to have a beach club, right? Where you have membership, you can have, you know, food, drinks. It can be somewhat exclusive, right? And you can control who comes in this area right here. Okay, that's effectively the backdrop of this case. Okay, you had a private beach club that tried to limit access to the dry sand over here. And the New Jersey Supreme Court said, no, 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 you can't do that. So, Joseph, walk us through the case. What were the very, very, very Jersey facts here? This is the guy's name was Tony, if it wasn't good enough. What are the facts here?
So basically they had this beach club there, and they tried to charge people membership and trying to keep people from coming in the area where they had the umbrellas and everything. And then one of the members, I guess, sued.
One of the members of the community, not a member of the beach club.
Right.
Right.
Sued the beach club and claimed that it was in violation because of the public trust doctrine that they were keeping people from using the beach.
Okay, right. So again, and this is a really New Jersey case, but if you can imagine, there was a guy. His name was Tony. He lived not too far away, and he liked to go to the water. He enjoyed going to the water, and for years he would cross. He lived on Raleigh Avenue. He would go straight down and walk to the beach. Right now, before I get too far, there was a public beach next door. I hope you all picked up on this in the reading. There was a public beach immediately next door, right? So why did Tony, right, decide to walk this way instead of walking 1 block to the right? Well, it was closer. Okay, so this case is ridiculous, right? There was a public beach 1 block away, and this guy chose to walk across a private beach club because it was shorter. This is New Jersey Supreme Court, and we'll do a couple of New Jersey cases. They are very, very, what's the right word? They're very much in favor of promoting fairness, right? They have a very little amount of respect for property rights, and you will see that very clearly. And this case illustrates it in spades. So Tony doesn't want to walk, you know, a block out of his way. I guess it's too far. Maybe he'll get sand on his toes, and I don't know, he'll hurt himself, whatever. So he says, I want to walk across it. So initially, they start charging fees. They charge a $700 annual membership, and they actually have Tony cited for trespass for walking across their beach. Now, the position of the beach changed somewhat over the years, over the course. Initially, they said you can't even pass this way, you can't go anywhere. They actually abandoned that position, which I think was correct. Under the common law, you need to let people cross. There's like, see a footpath where this red line is. So you should be able to cross through the beach. But they still said, we don't want people coming onto our dry sand. We have our umbrellas, and we have our, you know, weightlifting equipment, and you have other, you know, disco floor, whatever people do in New Jersey, right? By the way, I'm actually really sad because in the new edition of this textbook, they dropped this case. So this is the last time I can teach this case. I'm really sad. So I'll give you my meme. When I read this, I could not believe that the New Jersey Supreme Court, this is a Matthews case, actually held the law protects the right to sunbathe and generally enjoy recreational activities. This, of course, is the case of Jersey Shore, a show that's very near and dear to my heart. Seriously, as you may know, the situation is under indictment for federal tax fraud. He earned, God help us, almost $9 million in 3 years, and he didn't pay taxes on almost all of that. So he's in trouble. He's in big trouble. But this was back when he was still earning money and not spending money on lawyers. So I'll have to retire this meme with much sorrow. So back to the beach, if you can find it. No, okay, good. So we have the situation where they don't want people coming onto the dry sand, right? All right, Tyler, what does the court, I think a couple people got that one. Tyler, what does the court do here? Where's the beach, right? What does the court do here?
Supreme Court?
Yeah, the Supreme Court.
Basically,
Or actually, no, let's start with the lower court. What do the lower courts do?
The trial court, from what I understand, said that you have a limited right to, or you can access it, but only to a limited extent.
Right.
And they talked about like the limited horizontal access, the limited vertical access, but then the Court of Appeals said that no, you can't limit vertical or horizontal public access.
Okay, good. So initially, the trial court effectively did the common law. It said, listen, you have your vertical access, you can get across, and you have your horizontal access, which is like this 3-foot strip where the tide line is, right? Right where the wet sand, right? Or in Galveston, I guess the dirty sand, as it may be. So you have this limited right to access, right? But on appeal, the court took a much more expansive doctrine. So Morgan, what did the Supreme Court say on appeal?
Anything that's submersible water or covered by like either tidal waves would be absolutely separate and that they would have to
Okay. So, but Morgan, not just the thing that's submerged underwater. What about the dry sand?
There's access to that, but sorry, for the dry sand that they would have to pay for the upkeep and the maintenance of that.
Who's they?
Whoever crossed it.
Okay, but is the dry sand open to the public under the Supreme Court's ruling?
Under the public charge document.
That's right. Okay, so under the court's holding, right, and this is a significant holding if you think about it. Not only is it 3 feet by the tide line open to the public, not only is a vertical access open to the public, the entire area of dry sand, and you can mark this if you ever go to the beach where the foliage, where the plant life stops and the sand begins. That's usually referred to as kind of like the line. So everything from where the plant life ends and the sand begins down to the water is now up to the public. Right. Sumaya, can the private beach club exclude people from the dry sand? What's the fee? Yeah, how much is the fee going to be? Do you know how much what it was before? I think it's mentioned in the book. Yeah, the outset. $2, yeah, $2.50. So effectively, right? GTL indeed. So effectively, general fee for a public beach, which is $2.50. That is the fee they have to charge to get into their private land. So the beach club that used to cost $700, they can now only charge a $3 fee for. Not only that, they now have an obligation to provide lifeguards. They have an obligation to provide a cleaning and maintenance for the people on this beach. And these aren't their beach members, right? These are now you have Snooki in the situation crawling on their beach, right? So effectively, anyone can come here now. This is actually not very far from Seaside. If you want to get a little New Jersey geography lesson, I guess my public service is someone from there. It's actually fairly close to Seaside. It's on the Jersey Shore. Let's see. Zoom out. Yeah. So Seaside is right, or yeah, it's a little bit up there. Yeah, so it's pretty close. All right. Expand the public trust doctrine that now you need to have access to the private sand as well. They say, quote, because the activity of swimming must be accompanied by intermittent periods of rest and relaxation, the lack of an area available to the public would curtail the right to use the ocean. So effectively, because you, right, and this is why I made the meme, because you have a right to sunbathe, right, there's a right to sunbathe, you need to have a place to tan, and you tan on the sand. So and last time, the New Jersey Supreme Court said because you have a God-given right to tan, the sand must be there for you to tan on, right? You need to put that towel and chair and those fanning mirrors somewhere. So basically, this is the holding of the New Jersey Supreme Court. You have the right to swim and relax somewhere. So now the property rights of the owners are considered not quite as important, right? So Ty, what happens now to the land that was owned by this exclusive beach club? What's now the value of their land?
A lot less.
A lot less, right? Can you imagine if you buy a piece of beachfront property and your goal is to make it into a private club and you put a lot of money into it, so you're charging almost $1,000 a season and you probably have a certain caliber of customers. Now you have this, right? That's gone. So there's a severe diminution in value of their property, a significant diminution in value in their property, right? I'm pretty sure he had to shut down the beach club. I'm sure he had very nice facilities, whatever. I'm guessing he shut it down. I can't imagine he kept it in business. Afterwards, he said that the club owner, Robert Champetti, was incensed at the ruling, saying they don't cover his taxes and property, right? He has property taxes to pay. And guess what, boys and girls? He can't sell the land because no one's going to buy it from him. Why would you buy a beachfront property that you can't keep for your own property, for your own use? Yeah. So this was I mean, it might seem like a fun decision, but this is a significant issue. Later in the semester, we'll do a topic called takings, right? When the government passes a rule that diminishes the value of your property significantly, you can actually get compensation from the government, right? But this is not the government passing a rule. The government didn't change any laws. This was a judicial opinion that diminished the value of property. And it's actually something of an open question of whether a court decision can be considered a taking under the Fifth Amendment. We'll talk about that later in the semester. Yep. So right now, the value of the property significantly declined. All right. Okay. Questions? Yeah.
Was it 3 feet from the vegetation?
It's the 3 feet is 3 feet from the median tide line. So in the course of a given month, where is the median spot where the tide comes in, and then 3 feet beyond that. Because as you know, the tide comes in and out. So effectively, where is the tide line on any given day, right? And 3 feet from there, so you have enough time where the wet sand is usually. Other questions? I got nothing else. It's a short day, so have a wonderful day. Have a good weekend, and I will see you on Monday.